Hi, my name is Melissa Lauren, Content Specialist with Maryland Realtor's Strategic Communications Department. Welcome everyone and thank you for joining today's webinar, New Year's Resolutions to Stay Out of Realtor Jail, as the Legal Dream Team helps you kick off the new year with best practices to help you stay out of Realtor Jail. Today's panelists include James Beslity, Esquire, Associate Counsel for the Legal Affairs Department at Maryland Realtors, and James staffs the statewide forms committee. The department also manages Commercial Alliance Committee, which is responsible for the association's annual commercial symposium. And Mark Feinroth, Esquire, Director of Political Advocacy at Maryland Realtors, is our other panelist, and we are lucky to have him here as the legislative session just started a couple of days ago. Mark manages the association's RPAC efforts and staffs the RPAC Trustees Legal Action Fund Committee, Lockbox Consortium, and the Maryland Realtors Political Fund. The legal department teaches CE courses to members throughout the state, and both gentlemen are here to teach you today using the Socratic method. The webinar is all about getting your questions answered after their presentation. And at the bottom of your screen, you will see a Q&A box. We encourage you to place your questions there where they will be answered at an appropriate time. And all registrants will receive the presentation deck from today's webinar and have access to the webinar replay. So James, take it away. Thank you. Thank you
so much, Melissa, for that introduction. Greetings, Maryland Realtors members. I see we are at 169 participants, 170 participants and counting, which is great. Thank you so much for joining Mark and myself today for today's webinar, Staying Out of Realtor or Real Estate Jail. Fun, maybe not so fun fact, when you look through the Maryland Real Estate Brokers Act, imprisonment of up to 1 year is a potential consequence of many of the different violations we're going to be discussing today. I don't know, Mark, have you heard of anyone going to actual jail for?
No one goes to jail for violating the Brokers Act.
No one goes to jail. It's just in the Brokers Act. So that's good. That's good to know. But it does make for a fun, I guess, attention grabbing title. And certainly many of the violations and issues we're going to be talking about today are very serious in nature. And so it's certainly important to remain cognizant. We, of course, have an ethical duty as real estate licensees in the state of Maryland to stay up to date and informed about issues that are affecting the real estate community, industry rather, here in Maryland. And so that being said, if Melissa can bring up our slide deck, we're going to go ahead and walk through briefly the agenda of topics that we have planned for today, and then take it forward.
Okay, I'm going to do that right now. So if you want to talk about any legislative preview session to buy me a few minutes, I would appreciate that. Sorry, gentlemen.
Sure, no problem. I know Mark is very excited for the legislative session, which begins today.
That's right. So we have all of our new statewide elected officials are getting sworn in or to be inaugurated. Our new incoming governor-elect, Wes Moore, will be sworn into office a week from today, along with the lieutenant governor. The attorney general and comptroller have already been sworn into office for their terms coming up, and the General Assembly kicks off today. And then the realtors have a variety of different legislative initiatives that we'll be pursuing this year, but focusing really on housing availability and a few small licensing issues. The big housing availability issue will be a return to our accessory dwelling units legislation that was offered last year. We're going to try again with that this year.
Excellent.
Anyhow, Melissa's coming up with our slides, and then we'll kind of kick it off.
Yeah, absolutely. Otherwise, I know we're going to be talking about a range of topics today, anything from earnest money deposits, which are a perennial topic on our legal hotline, to completing your required continuing education credits, as well as a number of other topics that we've noticed have been repetitive, if you will, in consent agreements and settlement agreements that are populated on the Maryland Real Estate Commission's website. Speaking of the legal hotline, this is a great opportunity to plug that for you all. That is a member benefit that is available to every Maryland Realtors members. Bear in mind, it's not available to members of the public, but as a Maryland Realtors member, you can certainly contact us with your real estate related questions. The easiest way to access the hotline is through our website at mdrealtor.org/hotline. You can type that right in. You'll probably be prompted to log in, but once you do log in, you'll have the ability to reach us by phone. Our hotline hours currently are Mondays, Wednesdays, and Fridays from 10 to 12 and 2 to 4 p.m. Mark, myself, and Kathleen D'Artez, our Legal Affairs Department Director, all answer your questions by phone. We also accept questions in writing through our website, and there's a portal once you go to mdrealtor.org/hotline through which you can submit a written question, and we just ask that you give us 48 hours or so to respond to your question. Sometimes if your question is a little bit more complex, it might require us to do a little bit of additional research, so it could take a little bit longer. And just bear in mind that we're not giving you legal advice, merely legal information. But that being said, I would say that between the legal hotline and our statewide forms, those are two of our most significant member benefits that our members take advantage of, and we seek to provide the best possible service.
Okay, I am ready for you. Thank you for your patience.
Of course, no problem. There's always plenty to say in this space, so no shortage of comments.
And here we go.
We can go ahead and go to the second slide and get our agenda.
Look at that.
There we go. All right, so I think we'll start off certainly by talking about some recent real estate commission cases that we've been able to review to discuss some of the hotter topics, if you will, some of the more significant issues that are facing our members today. Specifically, we'll talk about earnest money deposits, continuing education, a little bit of advertising discussion as well, protecting your client's best interest in the ethics space, avoiding the unauthorized practice of law, maintaining good records. In my past professional life as an insurance defense litigator, I can't stress enough the importance of maintaining accurate, complete, thorough records of your transactions. That is for your benefit, but there's also a legal obligation to do so that we'll discuss. Following real estate commission guidance when offering incentives and rebates. I think Mark's going to touch on that. Talking about contracts best practices, touching on rules for assistance animals, source of income discrimination, a bit of disclosure requirements, and then we'll try and open it up. I know we're going to probably have a few Q&As in the Q&A box. So if you look at the bottom of your screen, there's something specifically marked Q&A. You can go ahead and put your questions in there, and we'll do our best to get to as many as we can. But of course, if you think of a question later or when I'm unable to get to your question, please take advantage of the legal hotline and submit your questions through our portal on our website. With that, I think we can go to the next slide. All right, so recent MREC cases, and as Mark said, no one's really actually going to jail. I think when we were putting this slide deck together, I commented on how bleak a jail cell that looks. But all that being said, one thing that I discuss very extensively in my ethics continuing education classes that I teach through our local boards and associations of realtors across the state is that this process, having a complaint filed against you in the real estate commission, it can be extremely stressful. Depending on how prepared you are and the sort of response you can file, you may be successful in having a complaint dismissed. But that being said, there are a number of complaints that make their way through. They may typically end up being settled between the licensee and the commission. But today, I think we want to kind of highlight a few scenarios that we've seen in some complaints and kind of break them down a little bit for you. One point that I'll make now, as we continue to update our website for everyone's benefit here, we plan on in the coming months incorporating a section where we highlight 2 or 3 summarized, of course, maintaining privacy of those involved, but highlighting the fact patterns of complaints that are settled and released by the Real Estate Commission, just so that you all can stay on top of the types of issues that the commission is dealing with, and know how to best, especially for those brokers, office managers, and team leaders that we have here, know what to focus best on in your regularly scheduled office meetings. But Mark, should we go ahead and jump into some of these scenarios here?
Sure. You want me to start covering the kind of the initial scenarios?
Yeah, sounds great.
Sure. Okay. So this first case was where a broker representing a buyer and their deal fell apart, and the broker decided that because he had worked so hard on the deal, he was entitled to some portion or all of the earnest money deposit, and decided to disperse it to himself. And the Real Estate Commission took a dim view of that. That's not really what the agency law provides for. And there's a very clear explanation in the statute as to how earnest money deposits can be dispersed. It's got to be done by mutual consent, or it's got to be done with a 30-day letter, or it's got to be done by interpleader. And the broker's decision to simply take it on him or herself was actionable, and the Real Estate Commission took a dim view of it and sanctioned the broker involved.
Absolutely, and a great time to bring up, even though we're going to probably talk a little bit about contracts a little bit later, great time to talk about when deals don't go to settlement. Of course, we all want to see our transactions go to settlement, but that is unfortunately not always the case. You're generally going to need 2 documents in order to terminate a transaction. So first, you're going to need to terminate the contract of sale, right? For that, you'll need one of 2 documents that we offer in our statewide forms library. You either need the mutual release of obligation under contract of sale, or the unilateral notice of termination under contract of sale. A lot of people will call the hotline and say the unilateral release, we call it unilateral notice of termination under contract of sale. The mutual release of obligation, that's to be used when the parties come together and say, look, the universe just does not want this transaction to go forward. We're both going to agree to release one another from the contractual obligations. And it's totally fine if that's the case, but that's when you would use the mutual release of obligation. The unilateral notice would be used when one party breaches the contract, rendering the contract voidable, such that the other party, the non-breaching party, has a basis to terminate the contract on their own without the consent of the other party. For example, if an earnest money deposit is not timely made, so let's say the buyer has 3 days to make that earnest money deposit from the date of contract acceptance. Day 4 comes along, prudent seller's agent confirms with either the escrow agent who's holding the earnest money deposit or the broker who's meant to hold the earnest money deposit. Has the earnest money deposit been made? No. All right, the seller has the ability to unilaterally terminate the contract of sale. It's an example there. But what's the other document you need? Well, you need, as Mark referenced in this hypothetical here, well, not a hypothetical, actual situation in the summary there, you need a release of deposit agreement. You need a piece of writing. It doesn't have to be our form, although I think our form is well designed to effectuate what the statute requires. You need a release of deposit agreement. So the parties have to agree as to how the deposit is going to be dispersed. And yes, often there is a disagreement between the parties as to how that deposit is going to be dispersed. And that's when other avenues of resolution become available to either the broker, or if the deposit's being held by a title company, as that's referenced in Maryland law, an escrow agent, pursuant to the terms of the escrow agreement. There are dispute resolution mechanisms contained in our Maryland Realtors escrow agreement as well. So something to be mindful of if you're ever in a situation where a transaction is not going to settle. You're going to need both a way for the contract of sale to be terminated, as well as that release of deposit agreement. Let's talk about continuing education requirements. I typically open every one of my CE classes these days with a discussion about this. Remember that we have to complete our 15 hours of CE for each licensing period, every 2-year period. When you go to renew your license with the Real Estate Commission, the Real Estate Commission will ask you a question in that license renewal application. Have you completed your 15 hours over this preceding 2-year licensure period? If you have not completed your CE hours, do not answer yes to that question. Do not renew your license. because periodically the Real Estate Commission will go back and audit a randomly selected group of licensees as far back as they want to go to determine if in fact the licensee, that group of licensees did complete the CE as they affirmed under penalties of perjury that they did in their license renewal application. And if it comes up that, oh, well, for this 2-year period, this licensee did not in fact do the 15 hours, that opens the door for the Real Estate Commission to act as a complainant themselves and file a complaint against you. And there are more of these complaints than I thought there would be. There's a rather significant number of them. In fact, I was on a webinar not too long ago where it was cited to me that at the end of last summer, around 40 complaints in this regard had been filed at one time by the commission against licensees. And the fine tends to run around $1,500 plus a $100 administrative fee. So this is a great chance, brokers, office managers, and team leaders, make sure you're reminding your agents, complete your CE, do it early. Once you renew your license and you begin that next 2-year period, you can start scheduling and taking those classes right away. There's no reason to wait for just, a few months or even worse, a few weeks before it's time to renew your license. Remember that there can be a little bit of a lag from the education provider reporting the fact that you took the class to the Real Estate Commission and that being reflected in your online record. So let's not play around with that. I don't want to see anyone get fined for anything, much less something like that. Make sure you're staying on top of your CE hours.
But the key point to remember, James, I'm sure all the licensees understand this, but the key point to remember is that the Real Estate Commission actually has your records online, and they have the ability to look without even inquiring outside of their own computer system as to whether or not your hours are complete or not. So if you check the box, they're going to know right away that it's not true if you haven't completed your hours. So it's just really not worth it to wait to the last minute, check the box, hoping that you're not going to lose your license or be out of status with your particular brokerage, or mess up a deal or something like that. It's just not worth it. Take that CE early. Give your education providers an opportunity to get those records filed digitally with the Real Estate Commission, and it'll be true when you check the box.
Absolutely. Great follow-up points there. Another similar scenario, broker makes a legal conclusion that there was no contract and releases the deposit to the buyer client. I saw this complaint. This actually ended up going to a hearing in front of an administrative law judge in the Office of Administrative Hearings. That's what will happen to a complaint if a 3-member panel of commissioners determines that it's more likely than not that a violation occurred. The matter gets a statement of charges is drafted and it's referred for a hearing before an administrative law judge. And in this situation, there was a lot going on, but unfortunately, the broker acted a bit rashly. They ended up releasing an earnest money deposit back to the buyer, who was in fact their client, and attempted to base that decision on their belief that a contract was never formed. If you have questions about whether a contract has been formed or not, based on a particular fact pattern, whether or not a particular disclosure or other addendum is required to have an enforceable contract, call the legal hotline. Call us before you start doing anything like that, because in this situation, the administrative law judge and by way of that, the Real Estate Commission determined that the broker had violated the Brokers Act by failing to release the deposit with the absence of a release of deposit agreement. And I will say that in this particular decision, there wasn't too much discussion about whether or not a valid contract had in fact been formed, but rather the focus was on the fact that a release of deposit agreement had never been executed. And that was very problematic to the ALJ in that case. Mark, do you want to round out our last little scenario there?
Sure. So the last one to talk about, this is a pretty common situation, but a recent case, an agent failed to, on a timely basis, send up the earnest money deposit to the broker or to the title company. It's an absolute condition of the contract of sale that the money be deposited within the date specified in the contract of sale. Failing to do so on the agent's part is a failure to represent the client and failure to assist the client in the appropriate manner in getting the contract moving forward towards settlement. Cannot be done, and if you don't get that earnest money deposit into the escrow account in a timely basis, or refer it over to the title company, you're violating your duty to your client and subject to discipline from the Real Estate Commission. And it can be a pretty steep fine. They will check the dates associated with the date of the contract and the date that the deposit was actually completed. So they have an ability to track back and make sure that the dates match up. And if they don't, there's a significant risk associated with the disciplinary action and a pretty hefty fine involved.
Absolutely. And let's not forget, we talk a lot about fines in this general space in this regard, but there's also always the potential that your license could be suspended for a period of time, during which time you would not be able to engage in providing any real estate brokerage services whatsoever. So be mindful of that as we go through some of these other issues.
And don't forget, if the Real Estate Commission also issues a guarantee fund award to the consumer damaged by whatever failure to act or breach the licensee is committed, it automatically suspends your license to practice. It suspends your license immediately if the Real Estate Commission issues a guarantee fund until you repay the guarantee fund for what they were out to reimburse the consumer for their losses.
Yeah, absolutely. Great point as well, Mark. Melissa, I think we can switch to the next slide. Advertising, one of my favorite topics. Bear in mind that the Real Estate Commission does have an advertising checklist on their website that is available to you. I think it's a good resource. As always, we love to see new and updated materials from the Real Estate Commission. And I think this is one document, one resource that we could potentially see some updates, especially in light of some of the newer advertising regulations that came down in April of last year. I'll go ahead and just jump off by talking about team names. I imagine we have a lot of participants here in today's webinar and folks who might be viewing this after the fact that are either members of a team or are in fact team leaders themselves or work at a brokerage that has teams. And I can't stress this enough. There's been a significant change to how team advertising needs to take place, and that's specific to the way that a team name and a brokerage name are represented in an advertisement. All right. So prior to April, there was in the Maryland Real Estate Brokers Act a statute that stated that the team name and the brokerage name needed to be directly connected, right? But there was no definition of what constituted directly connected. A number of Real Estate Commission complaints were going through the system, and that issue became quite palpable to the Real Estate Commission. Administrative law judges were citing the fact repeatedly that the phrase directly connected, as stated in the statute, was not further defined by any other statute or regulation. So what did the Real Estate Commission do? They enacted a new regulation defining directly connected. And the way directly connected is defined is such that there cannot be any other word, image, anything between the team name and the brokerage name, except for the words of, from, with, or at. So you would have ABC team of XYZ brokerage. No other words, symbols, or spaces between the team name and the brokerage name. I will say that I spend a considerable amount of time looking at electronic media, specifically social media platforms, specifically Facebook. And whether it's that particular issue or other advertising requirements, I see a lot of non-compliant advertisements. And I just want you to all bear in mind that once you put something on the internet, it's pretty much out there forever. Things are very easily searchable. You can go back and look things up pretty easily on various platforms back in time, that is. So bear in mind the requirements for an advertisement. It needs to be, your connection with your brokerage needs to be obvious. It needs to be obvious from the advertisement that you are connected with your brokerage. If you are going to have your personal phone number and email address in an advertisement, what else do you need to have? You need to have the phone number of your brokerage or office manager. You can never have your own phone number in an advertisement unless there is another phone number in that advertisement. Beyond that, of course, like I said, if you are a member of a team and you're going to advertise your team's activities, make sure that your team name is in fact directly connected to your brokerage name. Mark, do you want to talk about the one-click rule a little bit?
Sure, a little bit. I'll also kind of quickly address one of the questions that came up in the chat box.
Oh, excellent.
Excuse me. One of the questions was about authority to advertise another agent or another brokerage's listings. And it's very clearly referred to in the Real Estate Commission's advertising checklist. You must have authority to advertise. So if you're wanting to share information about another listing that's not your company's listing or your own listing, you really do have to have, as required by the statute and the regulation, authority of either the agent who's got the listing or the owner of the property to advertise the property. So you're not permitted to simply take another MLS listing or another advertisement that you've seen on social media and post it up to your own website or post it up to your own kind of advertising site. You must have authority to advertise from either the agent that's representing the seller or the seller, him or herself. But then I'll go ahead and kind of mention the, where were we again, James? Which one was I starting to pick up on?
We're going to touch on the one-click rule.
Oh, one click, thanks. So the other portion of the regulation that the Real Estate Commission updated this past spring, last March, was this idea of social media advertisements and the one-click rule. And what the Real Estate Commission recognized was that there is a significant number of social media advertisements and websites and platforms that limit the amount of content that the advertiser can actually post up. So, for example, on the for tweets and on the Twitter site, an individual advertising a real estate listing is limited to 280 characters. And there's a lot that's required for a real estate ad to get into 280 characters. So the Real Estate Commission adopted a one-click rule that allows for a hyperlink to be embedded into the social media posting. They define advertisements as including just about any kind of media, including social media platforms. So anything that you put up on Facebook or Twitter is going to be considered a real estate advertisement for purposes of the statute, and you're permitted to use in these limited content platforms a hyperlink to take the consumer who's viewing the advertisement within one click to a website with all the required information that's pursuant to the Real Estate Commission's advertising regulations and statute. The provision is, though, that it's got to be within the top 25% of the advertisement that the hyperlink is available, and within the top 25% of the website, all the required information, so that the consumer viewing the advertisement doesn't have to dig through either the website or the advertisement to find either the hyperlink or the required information in the advertisement. So that's all information that's available now in the Real Estate Commission's newest version of the regulation, and we expect them to issue an updated Real Estate Commission advertising checklist that includes both the connector words that James was referring to on the teams and groups regulation, as well as this one-click rule that the Commission adopted this past spring.
Mark, why don't we go ahead and touch on, we have a few open questions in the Q&A.
Oh, yeah. Okay.
Go ahead and address some of those. So Cheryl's asking, what are the Maryland laws for advertising company listings or other company listings that are not your own personal listings? Squeeze pages and landing page tools make this easy to do, but what are the Maryland laws to utilize these two tools properly? Well, I think Mark kind of touched a little bit on authority to advertise people's listings. Remember, if you haven't reviewed our exclusive right to sell residential brokerage agreement, now's a good time to pull up that document off of our website and actually read through the provisions. Sellers grant the authority to brokers to advertise their property. It's not that just anyone can start posting photos or what have you, advertising a particular property. I once had a question on the legal hotline, something to the effect of someone wanted to go and take pictures of a listing during a showing and start advertising the fact that this property was on the market. That is a big no-no. Definitely not permissible to advertise a property without the authority of the owner. And remember, as Mark said, an advertisement by the Real Estate Commission is pretty much considered any representation made to consumers that's in connection with your provision of real estate brokerage services. So it's a really broad definition of what constitutes an advertisement. So what if we have a few EMD questions. What if the EMD is deposited after the contractual deadline of deposit? Can seller use that as a unilateral notice of release later in the transaction? So we have something in legal parlance, curing a breach. So let's say you had 3 days to make an earnest money deposit and buyer did not do so. Day 4 comes, day 5 comes, buyer then makes the earnest money deposit. In those intervening days, seller did not elect to unilaterally terminate the contract using the unilateral notice of termination. Well, buyer has cured the breach. Buyer has made that earnest money deposit. So I think there would be a strong argument to make that the contract would remain in full force and effect. Let's see. So if the non-breaching party gives unilateral notice to terminate and the breaching party will not sign the mutual release of deposit, do you still have a contract? You do not still have a contract so long as the non-breaching party had a legitimate basis to terminate the contract. The only outstanding issue in that situation would be the disbursement of the earnest money deposit. A lot of confusion as to what is needed surrounding what happens when the settlement date comes and goes and no extension or release was made prior to the settlement date. Is the contract dead? Do you want to talk about that, Mark?
So again, it's a situation where the parties can agree to walk away with a mutual release, or it's a situation where the party that showed up for the settlement is in a position of issuing a unilateral termination. But if they fail to do so, the contract still lives on until one party issues a unilateral termination or the parties mutually decide that they're going to terminate the contract of sale.
Yeah, absolutely. Contracts do not simply die. They do not go away. They do not expire. They become voidable, as Mark said. Similar, what happens if the buyer fails to provide the EMD? Once that deadline to provide the EMD comes and goes, contract becomes voidable by the seller.
I think there's an argument to be made that the buyer side agent has a duty to inform the other side if the earnest money deposit, either the check or the EFT, has failed to clear. If there's some sort of a problem negotiating the earnest money deposit itself, the other side's got to be informed. And I also would recommend that listing side folks confirm that the earnest money deposit has cleared the account and is in someone's escrow account, either the title company or the broker, the buyer side broker, has the money in their account ready to go prior to settlement. I think that's a best practices that one should pursue and make part of their regular routine.
Yeah, absolutely. Should agents be following up with the individual or entity who's going to be holding an earnest money deposit to make sure it was timely deposited? Absolutely. Yes, yes, yes. One more before we move on to the next slide, and then we'll revisit questions later on. What is the appropriate way for an agent within a team to display their name in advertising? For example, Jane Smith with ABC team of XYZ Realty, for example. That's perfect. That's great. The connection between the individual and the brokerage is obvious. You have that direct connection between the name of the team and the name of the brokerage. Get that in a piece, in a piece of little clip art or whatever, and slap that on every advertisement that you have, and you're good to go. Melissa, I think we can shift to the next slide. Oh, perfect. So protecting your client's best interests, certainly, exercising reasonable care and diligence, managing expectations, presenting all offers in a timely manner, and remembering your statutory duties. These are all sort of themes that are, or actually statements, throughout the Maryland Real Estate Brokers Act and in our Code of Ethics. Frequently, when we're looking through complaints on the Real Estate Commission's website, exercising reasonable care and diligence, that's often something that's cited. as something that a licensee failed to do in whatever the particular fact pattern may be, and certainly managing expectations of your client. I remember asking my very own realtor once after I bought my own first house a couple of years ago. I said, what was the most difficult part? I think this would really help me. What is was the most difficult part about working with me? And we had a good laugh about the question. And then he said, honestly, it was the same thing that I am challenged with every single client: managing your expectations. So certainly, working with a mentor or a team leader, office manager, broker on that topic would be absolutely beneficial. Presenting offers in a timely manner. We of course have a legal statutory obligation, regulatory actually, I believe it is, to present all offers received on properties to sellers, including counteroffers. That obligation is also stated in the National Association of Realtors Code of Ethics, to present those offers and confirmation, provide confirmation to the other side, the individual making the offer, a counteroffer, that the offer has been received and has been presented to the offeree, is also part of that as well. And then statutory duties. I think a really good way to illustrate this is, of course, we have a primary duty of care, primary obligation to our clients, right? That is clear. But what's really important to remember is that there are a number of other statutory duties that you may owe to other parties in a transaction. And just because you have that primary obligation to your client does not mean that you're relieved from those other statutory obligations. Mark, any additional?
So it's hard when we're all trying to sell property and manage our clients' expectations and deal with an adverse party in a transaction. But it's important for agents to understand that they can never lie. They simply cannot lie to the other side about what exactly is going on with a particular transaction, how it's moving forward. They can't lie about characteristics of the property, the size of the property, nature of the property. If you have to answer a question, you can either decline to answer it, but you can never misrepresent. And misrepresentation is one of the largest area of complaints that the Real Estate Commission receives. And if there's something that you've said in writing, either in a text message or an email, that's going to end up being evidence as to whether or not you represented or misrepresented a particular characteristic or particular nature of the transaction.
Absolutely. I think, Melissa, I know we're running a little short on time. We can go ahead and move to the next slide. And then we'll tackle some additional questions. So unauthorized practice of law, another perennial topic here. Know what resources you have available to you so you can avoid the unauthorized practice of law. In particular, really try and avoid drafting your own forms. Certainly, if your brokerage has in-house counsel, that's one option. If your brokerage offers its own set of forms, or your local board or association of realtors has its own forms library, or of course we have the Maryland Realtors statewide forms library. There are many, many resources available to find a form that you may need or that a client needs to effectuate a transaction. And certainly, I'm on the legal hotline every week, and there are some calls that I get where, based on what I'm hearing, what a client really wants is a custom contract. And if that's what they want, they really need to retain legal counsel to effectuate that. Really want to avoid our realtor members writing their own addenda. I've seen too many situations where an addendum is written up, but the terms in the addendum actually directly conflict with terms elsewhere in the contract. And those terms are not struck out, and there's no provision for the terms in the handwritten addenda to supersede the other terms. And you then end up with a direct conflict, which can, tying back to what we were initially discussing, issues over disbursement of the earnest money deposit if the contract's not going to go forward. So something to really be on top of, just understanding all of your resources and knowing where to turn if there's something additional that you need in terms of drafting.
So, and this might not be a real estate commission violation, but you may end up finding yourself in a civil litigation or some other kind of a dispute involving how the contract's actually going to work. which might even be more difficult, more challenging than dealing with the real estate commission through an administrative proceeding. So practicing law, drafting documents, preparing blank addenda are never a good place for a real estate agent or broker to be.
At this point, I think we can turn to a few additional questions. I don't want to get too far behind. A question on unilateral release. Can this be used only when there is a breach, or if there is a breach, it can be used? So let's talk about the unilateral notice of termination a little bit more. So certainly if it can be used by a non-breaching party, it can also be used if a party has some other legitimate basis to terminate the contract of sale. For example, let's say the property is part of a condominium regime, right? How many days once the buyer has the condominium resale package in hand does the buyer have to terminate that contract? 7 days. So within that 7-day period, if the buyer is going to terminate the contract on that basis, the unilateral notice could be used in that instance. Very similar if the property is part of a homeowners association. Remember that the buyer has, if they don't provide the documents prior to the parties entering into a contract, the buyer has 20 days from the date of contract acceptance to deliver that homeowners, the seller rather, has 20 days to deliver that homeowners association resale package to the buyer. And then the buyer has 5 days to terminate the contract. And that's another scenario in which the unilateral notice could be used, for example. Let's see. What about doing a Facebook live tour of a home? Is that permissible only for your own listings? I would say yes, that would only be permissible for your own listings with the permission of your seller client.
Right, so that would be something you could do for your client only, but that you wouldn't want to post up for general availability on social media.
Right. What is the rule regarding video tours for buyer clients? If an out-of-state client cannot come personally and requests a video, what are the steps the buyer's agent needs to take to be compliant? Is requesting appointment as a virtual tour sufficient? The first stop would certainly be confirming with the listing agent if virtual tours are permissible, and certainly whether or not the recording of the interior of someone's home would be permissible. It's one thing to do something, live, for example, on FaceTime, but it's quite another thing to make a recording of the interior of someone's home and then transmit that. Let's see. Can I repeat the connecting words for team names? Always. Of, from, with, or at. That would be of, from, with, or at. Mark, this might be one that this one is escaping me. How far ahead of time can you renew your license? Mine is coming due December 2023, and I've completed all 15 CE credits. Is now too soon?
So I think it probably is. I don't think they send you notice, I think 60 days out from the Real Estate Commission that your license is scheduled to expire on a date. So they give you 60 days. It's either 60 or 90 days that they give you prior to the expiration of your license. They won't allow you to renew much more earlier than 60 or 90 days.
Let's just touch on a couple more before we move on. Can you please clarify what responsibility the title company has when the contract states they will be holding the earnest money deposit and they do not receive it? The contract says the principal will deliver. Well, any responsibilities that a title company may owe in connection with the earnest money deposit are going to be stated in the escrow agreement. Right. So certainly, this is actually a question that I get quite frequently. So that's a great question to pose in here. The signing of the escrow agreement. First the buyer, then the seller, then the title company. That's the order it needs to be signed. Buyer, seller, title company. There would not be any reason necessarily for the title company to agree to maintain earnest money that they have not received, right? So certainly explaining that to your clients, managing those expectations as we talked about in another slide, making sure that if a buyer does want their earnest money to be held by a title company, they identify that title company at the outset of your representation of them as an agent, and that the title company is one that does hold earnest money, not all of them do, and confirm what escrow agreement that they are comfortable using. We do offer our own escrow agreement that we developed in concert with the Maryland Land Title Association, but some title companies may have their own escrow agreement. Another thing to be mindful of.
And it's an obligation of the title attorney to ensure that they've got the fully executed agreement, escrow agreement, before they accept the money. So, and when they accept the money, the obligation that the written agreement obligates the title attorney to inform the parties if there's when the money is received, and if it's not received, or if there's a problem with it not being, whether the deposit has not been effectuated.
Mhm. Let's move through some of our slides. I know we have additional questions, and I will say, we'll do our best to provide answers after the fact at the conclusion of the webinar, but certainly you're welcome to pose questions through the legal hotline as well. So maintaining accurate and complete records of your transactions. Remember that you have an obligation as a licensee to maintain either electronic or physical paper files of your transactions, all documents related to your transactions. So the statute specifically says a copy of the listing, but also any other documents, emails, other written communications that may be relevant to the transaction. You have to maintain those for at least 5 years from the date a transaction closes, or I guess should have closed. I think that is, and I happen to really like this piece of clip art here with the binders coming out of the laptop screen. I think that's funny. But remember that that's not just some sort of arbitrary rule that's, should be a point of aggravation for you. It's very important. If you are in a position where you're facing realtor jail, you want to be able to go back and look through records of that particular transaction so that you can supplement your response to a complaint with documentation. Any opportunity that you have to undercut the allegations that are made against you in a complaint is one that you should take prior to that 3-member panel of commissioners reviewing the entirety of the complaint, the response, and any additional investigation that's been made to determine whether or not that matter is going to be dismissed or sent on to the Office of Administrative Hearings. Having those records is really, really critical. Make sure they're secure, in particular with phone conversations, especially if you're talking about something critical, whether it be financing or something to do with home inspections. Make sure you're following up those conversations in writing. Really, really important.
And I will say that the Real Estate Commission investigators are trained to check into the forms that you have used as part of your transaction, executing the agency agreement. They'll check to make sure that the understanding whom a real estate agent represents form, the date that it was issued. They'll check to make sure that the date the brokerage services commenced was after an agency agreement was executed, and they'll check to make sure that a dual agency consent was executed by both parties and affirmed by both parties if there's a dual agency issue. So you need to make sure that those forms are all signed and dated correctly, because they will check the chronology to make sure that you executed the agreements, executed the consents before providing services or in the correct order of the dance. So make sure that your clients are signing them correctly and make sure that they're dating them accurately, that the dates are correct when they're writing down the dates that they're signing the forms.
Absolutely. Let's go ahead and transition to the next slide. Mark, your favorite topic, incentives, rebates, and contests.
So the Real Estate Commission years ago produced a memo on incentives and rebates, and it's one of the most popular and downloaded pieces of information from the Real Estate Commission to this day. And incentives are generally the kinds of things that salespeople are looking for to try and promote their businesses, try to increase their listings, increase their client base. And incentives are perfectly legitimate kind of activities for sales folks to do to try and bring in more business, bring in more clients, bring in more listings, but they've got to be done correctly. You cannot, under the code and under the descriptions of the memorandum, offer games of chance or opportunities to receive a sales incentive. You've got to offer an incentive to all individuals similarly situated in exactly the same fashion for exactly the same time period. So it's perfectly legitimate for a salesperson to say that anyone who brings me a listing or signs a listing agreement with with me and my brokerage during the month of April 2023 will receive a flat screen TV when we close the sale, or any other kind of a sales incentive or spiff, as long as it's offered to everyone. The Real Estate Commission has taken a position on specific types of incentives being offered to particular individuals in particular fields of practice. So there's been these series of incentives that have been offered to teachers or to first responders or to emergency personnel. And they're kind of broadly referred to as the red, white, and blue incentives. And those kinds of incentives are perfectly legitimate. The Real Estate Commission has said they consider them acceptable under the provisions of the law, but you cannot offer games of chance for an incentive. You can't offer a drawing for a flat screen TV if you come to the open house. You can't offer a raffle or a roulette wheel as an opportunity to win a particular incentive. And then the same is true for rebates. Rebates can be offered in a particular transaction. You simply cannot pay a non-licensee for the provision of real estate brokerage services. So you can't pay for referrals from a non-licensee. So that could be an attorney, it could be an accountant, it could be a neighbor who's referring a business to you. You can't pay for referrals to a non-licensee. And that's kind of the broad outlines of the restrictions and permissions under incentives and rebates. But it's a very well downloaded memorandum that we'd be happy to share to anybody, but it's also simply available by visiting the Real Estate Commission's website. And the link is on your screen right there to download it from the Real Estate Commission.
So let me go ahead and switch to the next slide. Contracts. All right, I know we're running a little short on time.
That's you, James.
Yes, indeed. So certainly a lot of best practices here. Take a contracts class once a year to know about not just changes to our forms, but I often teach these classes, and practitioners who have been in the business for many years or decades are thankful to have had a refresher on basic contract law principles. One interesting point, a contract CE class at this moment in time is not required by the Real Estate Commission as a required course. It can certainly go towards your 4.5 hours of elective credits that you need to complete every 2 years, but it's not something that's required. So if you have the option to take a contracts class, it's something we'd strongly recommend. Present offers and counteroffers timely. This would include any offers to modify the terms of an existing contract. If you receive, for example, a request from a party to an existing contract to modify one of those terms, you need to present that to your client so that they can duly consider that request and provide a response to the other party. Certainly, if an offer is rejected, the seller should, that offer should be rejected in writing as a best practice. That's as simple as an email. Thank you very much for your client's offer. However, the seller has decided to reject it. We talked a fair bit about contract termination. So I'm going to go ahead and skip that bullet point in the interest of time. And we've talked about unilateral notice and mutual release of obligation a fair bit as well. Assistance animals, another topic that is pretty frequently raised on the legal hotline, and a number of best practices here as well. If a disability, if an individual's disability is observable, your request for documentation of that disability is going to be limited to a connection between the disability and the disability related need for an assistance animal. So what a housing provider, and I say housing provider because this is not necessarily just a landlord tenant issue. The way that the Department of Housing and Urban Development characterizes housing provider, it could be a condominium regime, it could be a homeowners association, it could even be a university providing housing to its students on its campus, as well as landlords. But the way that a housing provider is going to be able to verify that there is a disability related need for an assistance animal, which could either be a service animal or some other type of support animal is through a letter typically from a healthcare provider who is treating that individual that states that the individual has a disability. They do not have to specify what the disability is, and that the healthcare provider is confident, is prescribing essentially this assistance animal because it will help alleviate the symptoms or condition associated with that disability. That goes to the very next point, reliable documentation. These internet certificates that float around, essentially all you have to do is pay a fee and get a certificate for an emotional support animal, for example. Those really don't hold water, and the Department of Housing and Urban Development has said as much as well. There's generally not going to be able to be an ability to restrict breeds when it comes to assistance animals. If we're talking about a more exotic animal, there's certainly the ability to ask for a more detailed explanation about how that specific animal is going to assist the individual with a disability. And of course, over the course of this, you're going to want to be engaging in a good faith dialogue. I had personal experience with this as a landlord myself. I had a tenant who requested use of an assistance animal, and we did indeed have that good faith dialogue. And I really wasn't left with much choice but to allow it. But of course, remember, you cannot charge a pet deposit in connection with an assistance animal, because assistance animals are not considered pets. But any damage caused by that assistance animal is certainly deductible from the security deposit on a rental. And remember that a security deposit for rentals in Maryland cannot exceed 2 months worth of rent. All right, another topic that's come up quite recently in the last couple of months, again, because the Real Estate Commission has provided us with additional guidance, is source of income discrimination. If you go to the Real Estate Commission's website, on the main page of their website, there is a link to the document that you see in the left-hand corner of the slide, left-hand side of the slide here, rather. It's a 3-page document. The first page that you see displayed here actually goes through a recitation of all of the statutes and regulations we have in place currently in connection with source of income discrimination. But I think what is most interesting are the second 2 pages, because what the commission has done is provided us with some hypos, right? Some hypothetical situations as to what may or may not constitute source of income discrimination. We have a pretty striking one here. Matthias is advertising a home for sale in Riverdale. In the listing comments, he states that the seller is only accepting offers for cash or conventional financing, right? The Real Estate Commission has said that this is discrimination based on source of income. Remember that in Bright MLS, there is an option. You're not obligated to use this feature. And frankly, we would not suggest that you use it in light of this guidance to indicate what types of financing would be acceptable to a seller. Bear in mind that Bright MLS, wonderful multiple list service. They cover, however, multiple jurisdictions, and every jurisdiction has different laws and regulations when it comes to things like this, things like source of income discrimination that may affect features of the multiple list service. So something that again has come up quite recently. The representation of acceptable financing in the MLS, something that the Real Estate Commission says could constitute source of income discrimination. Disclosure of material facts, latent defects, and licensing status. So certainly, best practice, when in doubt, disclose. That's going to put the buyer on notice. I'll just briefly go over the distinction between material facts and latent defects. So remember, the obligation to disclose latent defects is that of the seller. The seller has an obligation at a minimum when they're filling out that Maryland residential property disclosure and disclaimer statement to disclose any known latent defects. And a latent defect is going to be any condition that is not readily ascertainable based on a careful visual inspection of the property that could pose a health or safety risk to a buyer or any guest of the buyer in the home or any other occupants to the property. So that's not going to be anything and everything that could be quote unquote wrong with the property. It has to be not readily ascertainable based on that careful visual inspection, and it has to pose a health or safety risk. On the other hand, Mark, do you want to touch on material facts, a much broader?
So sure, the material fact is an issue that gets you in trouble with the Real Estate Commission, because that's an obligation of the licensee, the real estate agent, to disclose. And those are issues that have something to do with the particular transaction or the particular property. And they run to any kind of an issue that would affect a buyer or seller's decision to buy or sell, or a term or condition of the contract of sale that the buyer or seller might wish to offer or accept. So that might be an issue of whether or not a particular improvement was executed or repair was executed by a licensed home improvement contractor, whether or not the buyer might be interested in ordering up a home inspection or requesting a home inspection addendum, property inspection addendum as a term of their offer to purchase if they knew that there was a damage repaired from a storm or from a tree or from a fire or something like that falling through the particular property. So those are the typical material fact issues that we encounter on legal hotline. But they are requirements and disclosure requirements of the licensee and could implicate you for a real estate commission complaint if you fail to disclose.
Melissa, I know we're just about out of time. Do we have any additional time that we can allow to answer a few more questions?
I can check right now.
In the meantime, I'll just try and get through a couple of these here. We'll go ahead and save the list though, and we have everyone's. If you answered your question with your name, we can get back to you through our system and get you some answers to those questions. You're also welcome to submit them through the legal hotline. Do you need an escrow agreement signed when your broker is holding the earnest money deposit? Nope, do not need an escrow agreement for that. What happens if a complaint is filed after the 5-year period, therefore you no longer have the records? Well, there's no requirement that you at that 5-year deadline delete everything that you have. In fact, if you have the ability to maintain your online records, if they are maintained online or virtually, I should say, in the cloud, maintain them longer. For most real estate commission complaints, there is a 3-year statute of limitations. So someone asserting a complaint, 5 years after the occurrence or incident, there's a strong chance that it's going to be dismissed based on that statute of limitations.
I did see one. Is there any movement towards required seller disclosures and elimination of disclaimer, noting that some states may do that?
That is the case in many states. There is no option to disclaim. Rather, the seller, most sellers, of course, there are some exemptions, have to answer disclosure questions, whether or not they answer yes, no, or unknown. Right now, there is no specific movement or move to go in that direction, to my knowledge. But that's
I would only see the Real Estate Commission asking for that authority and the General Assembly granting it. It's not gonna, the General Assembly won't do that at the Realtor's request, and I don't see the Real Estate Commission asking that question. Asking for that authority. That's and of course the obligation, whether you disclaim or not, sell the property as is or not, the latent defect disclosures are still an obligation of the seller, and the material facts are still an obligation of the agent, whether you're selling as is or not.
Mark, there were a couple of questions. What about drawings at broker opens?
Drawings for prizes at broker. If it's only licensees that are coming to the broker open, then you're permitted to do that. It's not an issue for consumers. So you're permitted to do drawings for amongst licensees to draw them to a broker open, but make sure that it's only a broker open that you're doing it at, not an open house.
Giving gift cards to individuals who give you a referral.
So you can do that for a modest de minimis amount. I think it's the IRS rules are below $50. So you can do something nice for a neighbor or a business associate who sends you someone, a particular client or something like that, but you can't pay a fee for brokerage services, and that would be a referral as brokerage services. Gene Simontelli asks about, can a seller ask for cash only to purchase the property? Don't put that in your advertisement. Don't say that in your advertisement. Your seller can choose amongst offers and take the financing offer that they prefer. If it's cash only, your seller can elect to accept the cash only offer because that's what they prefer, but you cannot advertise that preference. So don't do that.
I think that answers a number of questions in there. One thing I will say, for when it comes to properties not qualifying or not getting past an appraisal for certain types of loans, that's one area where I'd love to see a little bit more guidance from the commission, because that is the case for many, for example, distressed properties. There is no way that they would appraise through a VA appraiser, but based on the guidance we have from the real estate commission, essentially you cannot represent that, the seller can't represent by way of a listing that they will not accept VA financing. But as Mark said, the seller can, consider the totality of an offer and make a determination as to whether or not they're going to accept or reject it. There is a little bit of a carve out there. Condominium buildings typically need to get FHA approval if they are going to, in order for units to be financed with an FHA loan. And it's perfectly fine to represent if that a building has or has not been FHA approved. You can make that representation, but careful with that. Don't say we will not accept FHA offers. What you're saying is the building has not been FHA approved, and that should be enough for prospective buyers who may be plan to use an FHA loan. Well, I'm not going to bother making an offer on this property because the building hasn't been approved by the FHA. Right, and I think Melissa, we do have a way we're going to go ahead and save our question and answer feed here so that we can get back to those of you who we weren't able to either directly address your question, or I know we had a number of similar questions here in the Q&A that we I think addressed with one or a couple of different answers. But any final words, Mark, on staying out of realtor jail?
So be honest, use the forms, date them correctly, and you'll mostly stay out of trouble. And be careful when you're handling money and distributions of money. Those are easy complaints to avoid and easy complaints to prove if you don't do it correctly.
Mm-hmm. One thing I will say, I do, as well as all of us here in the legal affairs department, we do speak at brokerages. We do speak at individual brokerages, whether virtually, or I'm happy to come to wherever you are in the state of Maryland and talk to you, not just about this stuff, but any type of legal issue that may be of interest to you. For example, I'm going to be speaking with a brokerage tomorrow about our exclusive buyer tenant residential brokerage agreement, just doing a deep dive into that form, issues of agency as well. So I know that different issues affect different brokerages in different parts of the state differently. In sessions like this, we of course want to be as broadly applicable as possible. But if for whatever reason you'd like one of us to come and speak to you at your brokerage, please contact us here at Maryland Realtors, and we're more than happy to accommodate that.
Yeah, and that leads nicely into the call out for the questions. As always, you can submit your questions via electronic form at mdrealtor.org. You just click on legal, and then the legal hotline submit question online, and then you can get answers readily. There's always the legal hotline. It's open Monday, Wednesday, Friday from 10 to noon and 2 to 4 p.m. And that phone number is 443-716-3502. All registrants will receive the recording of this webinar, and at a later date, we will also share this on our social channels and our YouTube channel. You'll find a whole host of webinars there as resources for you. So thank you both, Mark and James, for your expertise, and thank you all for attending.
It's our pleasure.
Thanks,
everyone.
Take care, everybody.
Take care. Bye-bye.